With the scandal that is modern-day policing, people from all walks of life are falling victim to police arrest and detention for merely expressing an opinion or saying mean things on social media, because of spiteful, false allegations made by a neighbour with a grudge, for exercising their right to peaceful protest, or for not showing a police officer the deference they so baselessly feel entitled to. We are now undeniably living in a police state, a dystopian society that echoes the warnings of George Orwell's 1984, and so it's more important than ever that people are aware of how the system works and how to navigate it. In this video, I'm going to discuss the process of being arrested, interviewed, and detained in custody at a police station. This can be an extremely distressing experience, and I think it's important to know what to expect and to be aware of your rights. So, what happens when you are arrested? First off, if a police officer comes anywhere near you, get your phone out and film them. This is absolutely imperative. Better still, if there's someone else with you, ask them to film because you won't be able to do so once you are detained. The police hate being filmed because they hate accountability, and to deter you from doing so, they may threaten obstruction. But civilians have every right to film the police, and unless you're somehow restricting their movement with your camera, you are not obstructing them. If they threaten you with obstruction, hold your ground and ask them how it is that you filming them is preventing them from carrying out their duties. If the police are filming you on their body-worn cameras, which they should be if carrying out an arrest, as data handlers, they are obliged to make you aware. The arresting officer should identify themselves, but they often don't, so it's good practice to ask on camera for their name, badge number, and which station they're based out of. They should tell you which offence or suspected offence you're being arrested for, and then caution you. The wording of that caution is you do not have to say anything, but it may harm your defence if you do not mention when questioned, something which you later rely on in court. Anything you do say may be given in evidence. They should then provide you with the grounds of the arrest, which is a brief overview of the allegation as opposed to a detailed account of the accusation and their evidence. Something along the lines of, for example, it's alleged that on this date and at this place you kicked a policeman in the bollocks. The police also have to have a necessity for arrest, something they seem to forget, and they have to provide you with that necessity. Failure to caution a suspect or provide them with the grounds or necessity for arrest makes it non-compliant with Pace Code G and can make it an unlawful arrest. If the police don't provide the grounds and necessity right away, make sure that you ask for them. The police are notorious for arresting people on a spiteful whim and then attempting to justify it when they've had more time to think something up. Demanding the grounds and necessity up front not only makes it harder for them to bullshit down the line, but it also puts them on the spot. As we know, the average copper would need watering twice a week if any less intelligent, and so will often come out with a justification for arrest that is wholly inadequate when having to think quickly. After making the arrest, they will likely do a pat-down search to, where applicable, seize items they believe relate to their inquiries, and to make sure you don't have anything on you that you could use to harm yourself or others. This should be done by a member of the same sex, but it's not a legal requirement unless it's a strip search or one that involves removing more than outer layers of clothing, e.g. your coat. You don't have to assist with the search by lifting your arms or turning around, etc. when told. Disregarding regulations and the law, many police constables will apply handcuffs as standard, but this can constitute civil trespass and assault unless they can provide an objective necessity and ensure it's proportionate. It's a use of force which they must document. The use of handcuffs would probably be legally justifiable if, for example, the suspect has a history of attempting to evade arrest or being violent upon arrest, or they are actively resisting arrest. Refusing to comply with arrest is not the same as resisting. I always choose to lie on the floor and go limp, making it as difficult as possible for the tyrants without breaking the law. This means 4 officers are required to safely transport you to the van, with 2 lifting you under the arms and 2 carrying your legs. The handcuffs used in the UK are rigid cuffs, and they can be applied front stack, back palm to palm, or rear stack, which is the most uncomfortable and should only be used for a detainee who poses a serious risk to themselves or others. If you have any health conditions that exacerbate the pain caused by the cuffs or they feel too tight, be sure to let the police know. They're responsible for safeguarding you and should assess the cuffs, making sure they can fit a finger between the cuff and the wrist and that the cuffs are double locked so that they don't tighten any further. It's a good idea to verbalise what the police are doing and the effect it's having so that it's evidenced on their body-worn camera footage should you have grounds to sue or complain at a later date. If the police come to your home address to arrest you, with some exceptions, they have no power of entry if the alleged offence for which they intend to arrest you is summary only, meaning it's a less serious offence that can only be tried in the magistrate's court. If the offence is indictable, a more serious offence tried at Crown Court, or they have a warrant, they can enter your home. In this case, or any other scenario when they have statutory powers of entry, it's best to let them in, otherwise they'll use the big red key to put your door in. There are other instances in which the police have power of entry when making an arrest or carrying out another statutory power, some of which include to capture someone who is unlawfully at large, to arrest someone for breach of bail, driving under the influence of drink or drugs, or for causing fear or provocation of violence under Section 4 of the Public Order Act, and to save life and limb. This is by no means an exhaustive list, and for more information, it's best to consult Section 17 of PACE, which determines most of the police powers of entry. Before letting them in, I advise always asking what legislation they're relying on for power of entry and asking them to explain the legal basis. The police are supposed to let you know when they don't have powers of entry and to differentiate between a request, which you can refuse, and a legal right of entry. So, after being arrested, cautioned, and typically searched, you'll be transported to the police station. Custody suites are often busy, and the booking-in process takes far longer than it should on account of police being cognitively challenged and taking an inordinate amount of time to type in detainee details. If the custody suite is busy, you'll be kept in a holding area with your arresting officer. Once a custody sergeant is free, your arresting officer will bring you to their desk. The arresting officer must then provide the grounds of your arrest so that the custody sergeant can decide whether or not to authorise your detention. They won't make you aware of this, but you have the right to make representations if you believe your detention is not lawful and that you should be released. This has pros and cons. The custody sergeant, in spite of his legal obligation to ensure your detention is lawful, will always side with the arresting officer and authorise your detention regardless. But there is a sound recording camera located on the ceiling above their desk, so if you do make valid representations, this could assist your case if you go on to sue the Chief Constable for false imprisonment. On the flip side, you are under caution, and anything you say could assist their investigation if you're not careful. Once the custody sergeant has authorised your detention, legal or not, they will then take any items you have on your person, which they will log and retain for the duration of your stay in custody. You will also be searched again ahead of being placed in a cell. The custody sergeant should ask if you understand the reason for your arrest and will ask for your personal details, including your full name, date of birth, occupation, address, ethnicity, etc. You don't have to answer any of their questions, but if you don't provide your name, date of birth and address, they may hold you until you can be put before a court where refusal to provide these 3 pieces of information is a criminal offence. So I always provide my name, date of birth and give my address as no fixed abode. You will also be asked a series of questions about your mental and physical health, any injuries you've incurred, your state of mind, if you need to see a medic or have any drug or alcohol dependencies, etc., to assess your level of need and supposedly to determine appropriate care and level of observation. Again, you don't have to answer these questions, and again, there are pros and cons. The benefit of answering them is that if you do have vulnerabilities, they are documented, the police must make sure they treat you accordingly, and if they don't, they can't claim ignorance of your needs at a later date. On the flip side, the police love to acquire every bit of information they can and weaponise it against you. Furthermore, in my experience, they don't give a single shiny shit about your well-being and will treat you appallingly regardless of any mental or physical health conditions. Everything you tell them will be stored on the PNC, the Police National Computer, and the PND, the Police National Database. The custody sergeant has to make you aware of your ongoing right to legal representation and ask you whether or not you would like to speak to a duty solicitor or one of your own. Representation at the police station, whether by the duty solicitor or one of your choosing who is signed up to the police station duty scheme, is always free of charge. A lot of people make the mistake of thinking that if they have nothing to hide, they don't need a lawyer. But a solicitor will be aware of all the tactics police use to try and get you to incriminate yourself, whether you're guilty or not. They will be aware of your rights and entitlements and can advocate for those. They'll make sure the interview is PACE compliant, take notes which can be useful at a later date, and they can advise you on the best approach during the interview and do so with the benefit of not only legal expertise, but having pre-interview disclosure, which gives them more detail of the allegation and some of the evidence that will be presented in interview. The only downside to requesting a solicitor is that it can mean you'll be in custody slightly longer if, for example, the duty solicitor is in another interview at the time of yours, or if you choose a firm that isn't local and they have to either travel or find local cover. Many people believe, thanks to TV shows, that they have a right to make a phone call. This is not the case. You only have a right to have someone informed of your arrest, and the custody sergeant should ask if you require this. Phone calls are discretionary, although surprisingly, whilst in the cell, 9 times out of 10, I've been allowed to make and receive often multiple phone calls to and from friends and family. I suspect this is because the calls are monitored and the police hoped I or the other person would say something incriminating or informative. Lastly, the custody sergeant should offer you a copy of PACE Code C, which sets out the legal requirements for your treatment in detention and the questioning of suspects. It doesn't make for compelling reading, but I suggest accepting this so you can inform yourself of your rights. It also helps to pass the time. Once the booking in process is complete, you will then be taken, usually by a detention officer, to your cell. It will be windowless, stark and claustrophobic with next to no ventilation. The bed is typically a solid moulded concrete or plastic base integrated with the wall and floor, and will have a thin plastic mattress and pillow. There will be a CCTV camera, a toilet, a sink, and an intercom which you can press to speak to custody staff. More than a few people have told me that when in custody, they didn't use the toilet because of the camera. So to allay anyone's concerns, the area of the camera that covers the toilet is blacked out, so you can't be seen when using it. Obviously, this is a really awful environment to be stuck in, especially when you have no way of keeping track of time and don't know how long you'll be locked up for. I'm diagnosed with ADHD, PTSD directly attributable to police harassment and detention, and some physical health conditions that combined make being detained truly unbearable. So I really have to get a grip of myself and formulate a plan to keep myself from breaking. The first thing I always do when the cell door closes is request a list of items I know are available to help pass the time and to make myself more comfortable. That list includes a cup for water and maybe some squash, loo roll, a toothbrush and toothpaste, soap, a pen and paper to make a note of everything they do wrong, books, a blanket, joggers and a sweater, custody greys as they're known in the activist community, magazines, puzzles, and food. In some custody suites, you'll be given a food menu, whereas in others, the detention officer will just reel off the vegan options. The vegan offerings are almost always some kind of pot noodle, an all-day breakfast, a pot of fruit, and lasagna, although Norfolk Police might be a bit reluctant to give me one of those after my repurposing of them the last time they arrested me. Most of it tastes like it's been blended up, reconstituted, freeze-dried, rehydrated, and microwaved 5 times. If you have genuine religious, ethical, or health-based dietary requirements, they should cater to this. You can have food brought in by friends and family at police discretion, but if they do allow it, the food will have to be in a sealed packet. I've had some detention officers look at me like I think I'm the Queen of Sheba when I tell them I have a list of items that I would like. And one Norfolk Constabulary detention officer once brought me a single 1970-something copy of Reader's Digest from their extensive collection of books as a big fuck you. You do get the odd DO who will treat you like a human and provide what you reasonably ask for, understanding that you're innocent until proven guilty, and that being detained for the purpose of an investigation isn't supposed to be a punishment, nor a chance to exercise their weird, pathological need to control and torment others. But even in the rare instance you do get one that treats you with some semblance of humanity, remember they're the ones locking that big steel door and they're not your friend. Once I've got all my bits and bobs, I'll request to speak with my solicitor and then alternate between trying not to go crazy, sleeping, reading, trying not to go crazy, doing puzzles, eating, trying not to go crazy, making notes, and repeatedly asking to call a friend until they stop pretending to be too busy to facilitate it. I sometimes ask for a shower, or definitely if I'm staying overnight, and if I'm really going up the walls, I'll ask to go into the rec area. This is a small, secured yard where you can get some fresh air and kick a ball around with incredible vim, perhaps pretending it's your arresting officer's head. Under Pace Code C, the police must ensure all of your basic needs are met, including access to medical care, toilet and washing facilities, and food and drink, as well as rest and exercise if you're kept more than 24 hours. Distractions such as books and puzzles are discretionary but unreasonable to refuse in my opinion, as mental stimulation and enrichment is a basic need, especially in such circumstances. On many occasions, the police have failed to provide me with even the basics. For example, not sending a medic to see me when I've needed and repeatedly asked for one, not letting me shower, and not letting me rest by pretending that the extremely bright lights can't be dimmed or switched off. I have been treated like absolute shit by police and detention officers whilst in custody. During one stay, Custody Sergeant and Police Federation Rep 783 Greg Struthers aggressively ripped a blanket off me when I had nothing on my arms and legs and was freezing cold. I've also been pinned to the floor by numerous officers, including males, and had all of my clothes cut off. I've been forced to strip and had one big old Bessie from Thorpe Wood lift my head up by my hair and smash my face onto the floor before cutting off my necklace. And that's just the tip of the iceberg. So it's important to make note of how you're treated and by whom, all the requests you make, and any other relevant details about your time in custody. Detention officers are civvies, but they do have shoulder numbers, so it's a good idea to take a note of those as well, should you seek redress at a later date. At some point during your stay, if you've been arrested for a recordable offence, they will take your fingerprints and photograph. A recordable offence is one which could result in a prison sentence if convicted, although there are a few exceptions to this. For example, Section 5 of the Public Order Act is a non-imprisonable offence, but one which is still recorded on the PNC. Non-recordable offences such as driving without insurance or non-payment of the TV licence will typically still be logged by the police and may be recorded on the PND. The police can use reasonable force if you refuse to provide biometrics, your fingerprints and photo, though I imagine that would be extremely difficult. I mean, would the photo show one pair of hands holding the detainee's head still and another person prizing their eyes open? I don't know, but maybe next time, if I'm feeling brave, I'll find out. I've always provided my biometric data since they already have it from the first time that I was arrested some 15 years ago, but I always let them know and ask them to record the fact that I do not consent and am only complying under the threat of violence. Although it's less common for them to do so, the police can also take a DNA sample such as a mouth swab or strand of hair without your consent, but they do need your consent and the authorisation of a senior police officer to take samples such as blood and urine or dental impressions. If you're not charged or convicted with the offence for which you've been arrested, your biometric data should usually be removed from their database, but it's not a bad idea to contact them and make sure. In some circumstances, the police can apply to retain your data. When this process is complete, you will then be in your cell until the police get around to interviewing or releasing you. They will often leave you in there for hours and hours on end with zero justification, simply because they're weird, malicious little bastards, or hope that the longer you're left to sweat, the more likely it is you'll spill your guts in the interview. Unless you're arrested under the Terrorism Act, in which case you can be detained for up to 28 days, the police can only hold you in custody without charge for 24 hours for a summary-only offence. If you're arrested for an indictable offence, this can be extended by a further 12 hours if a superintendent or any rank above approves it. In rare cases involving very serious crime, the police can apply to the magistrate's court to extend the detention to up to 96 hours in total. The police have an ongoing duty to make sure your detention is lawful and necessary. An officer holding the rank of inspector or higher must make a review of your detention no later than 6 hours after you're first detained. They must decide whether or not there is sufficient evidence to justify continued detention, and if it's necessary to secure or preserve evidence or obtain further evidence by questioning. They must consider if the investigation has been conducted diligently and expeditiously, or if there have been any avoidable delays, whether or not continued detention is proportionate to the alleged offence, if your rights and entitlements have been met, and if you're medically fit to remain in custody. If any of this criteria is not satisfied, it could make continued detention unlawful. But of course, this review, an important duty, is seen as nothing but a box to tick for the police, and they will almost always sign off on continued detention. After the initial 6-hour review, another must be conducted every 9 hours. When the police decide they can be asked and that you suffered enough, they will get you in for an interview. If you've opted to speak to a solicitor, you'll have a consultation with them first. During this consultation, the solicitor will brief you on the police case and discuss the best course of action. In my opinion, 9 times out of 10, it's best to go no comment, and most decent solicitors will advise this. Anything you say can inadvertently help the police investigation. For example, if it was alleged that you assaulted someone, you might say something like, "He was threatening me." Whilst this would be a reasonable defence to assault if those threats put you in fear of immediate violence, what you've effectively done there is put yourself in the location of the alleged offence at the date and time and insinuated that you did use force. So you've potentially ticked boxes that may not have been ticked. Not only that, but the police ask questions in a leading and manipulative way. They'll choose their wording carefully, and another tactic they like to employ is playing good cop. They'll feign empathy, saying something like, "So-and-so called you a fat wanker, that must have really hurt, and I can understand why you were so upset," in the hope to build enough rapport and trust that you'll admit to what you're alleged to have done under the misguided belief that they'll get it, and your justification will supersede the legal parameters of your actions. Remember that no matter what approach the police take, whether it's acting pally or going in hardball or trying to wind you up to provoke you to speak, they will be hell-bent on getting a charge. They don't want to eliminate you from their inquiries, they want to establish your guilt. Even though, of course, only a court of law can do that. You can answer no comment to some questions and answer others, but in my opinion, this is a bad idea, as the questions you refuse to answer might identify weaknesses in your narrative or areas that are sensitive and make you appear guilty. Your other option is to serve a pre-written statement, which you can either read yourself or ask your solicitor to read for you. This is a good option if you have a strong, provable defence, as you can rebut the allegations robustly without leaving yourself open to probing questions. If you don't know the specific criteria for the offence you're being investigated for to be made out and the specific wording of the legislation, if you're not familiar with the interview process and how the police operate, your best option is always to go no comment. The fact this is the least favourite option of the police and the one they seem to find the most frustrating says it all. You should, however, be aware that if you are charged and prosecuted, the court or jury can draw a negative inference from your no comment response in police interview, especially if you provide an account in court which you could have given at the time of the interview. In my experience, this has never once been an issue, and on the rare occasions it has been mentioned, I've pointed out that I chose to go no comment following legal advice. You can also explain the choice to go no comment as needing more time to process and understand the allegations and evidence. Lastly, on going no comment, you don't actually have to say no comment. You can just sit there staring at them blankly and silently whilst they ask their questions as if they're talking to themselves. It's awkward, jarring, and throws off their pacing, and in my experience makes them feel very uncomfortable, which amuses me greatly. The interview will be audio and visually recorded, so be mindful of any expressions you make, as if you smirk or pull a face, they may comment on this. If you don't think that you can take them seriously, or if you feel nervous and don't have much of a poker face, you can turn your back to them. That way you don't have to worry about giving anything away, and you get to dent their raging egos with your seeming lack of respect. You can't refuse a police interview, but you can refuse to go into the interview room. In this case, an officer will come to your cell to conduct the interview, which they'll record on their body-worn camera. You can, of course, completely ignore them if you want to. A final note on the interview process: if they have seized any of your devices as part of their investigation and these devices are password protected, they may pressure you to give them the passwords and issue you with a Section 49 notice under the Regulation of Investigatory Powers Act 2000, better known as RIPA. Failure to comply with this notice is a criminal offence under Section 53 of the same Act. This legislation is primarily intended for serious crime, and in more pedestrian cases, it's extremely uncommon for anyone to be prosecuted for failing to provide passcodes. I've been threatened with this legislation several times and have never handed over my passcodes, and I've never been convicted under RIPA as a result. The potential penalty for not complying with the Section 49 notice is 2 years imprisonment, and up to 5 years if the case involves national security or child indecency. Once the interview has finished, you may have another chat with your solicitor if either of you deem it necessary, and then you will likely be taken back to your cell whilst a charging decision is reached. If the police decide they have no case against you and have exhausted all avenues of inquiry, or the allegation has been withdrawn, they will release you with no further action. If you are released under investigation, it means you're still a suspect and the investigation is ongoing, but you have no bail conditions and no set return date. You may be contacted and charged at any point in the future, although there is a 6-month statutory limit to charge if the offence is summary only. If you are released on pre-charge bail, aka police bail, it means that you're still a suspect, the police investigation is ongoing, and you'll be given a set date to return to the police station to answer bail, and may be subject to conditions relating to the case, for example, not to attend the scene of the alleged crime, or not to contact the alleged victim or any co-accused if applicable. Bail conditions have to be necessary, proportionate, reasonable and enforceable, and if they impede on your rights or are otherwise unjustifiable, you or your legal representative can make submissions for them to be withdrawn or amended. If you've been charged and released on bail, it means you have been formally charged with an offence and released pending your plea hearing at court. You may also have bail conditions. In what should be extreme cases only, for example, if you pose a credible risk of absconding or a serious risk to the public, the police may refuse bail post-charge and keep you in custody until the next available court. The court will then decide whether to release you on bail or remand you in prison custody. If you do get put on remand, you can appeal. Breaching bail is not a criminal offence, but you can be arrested for it. Breaching post-charge bail is much more serious, and if arrested, you will be put before the next available magistrates' court, where a judge or bench could impose stricter conditions or even put you on remand until your trial. Again, if they do put you on remand, you can make an appeal for bail. Assuming you're released from police custody after being arrested, a detention officer will come to your cell and escort you to the custody desk, where a custody sergeant will inform you of the charging decision, any bail conditions you might have, and any other action you must take, e.g. a bail return or a court date. They might ask a few questions to make sure that you're not going to go off and top yourself, and then they'll give you your stuff back in a plastic bag. I advise asking for a copy of your custody record, which you are entitled to and is useful to have. They will ask you to electronically sign the custody record before you leave, and I used to spend a good 20 seconds just scribbling all over the pad and then commenting with a straight face that it's a difficult signature to replicate because their bemused reaction to nonconformity is always comical. But now I just refuse to sign because it's something of a concession and means agreeing to their documentation, which I haven't even read and may not be accurate. You don't have to sign anything the police give you, and they can't make you, which leads me to a final point that I forgot to mention earlier. If, after being cautioned, you make what the police refer to as a significant statement, being one that is relevant to the case against you, and that statement wasn't recorded on their body-worn camera, they may make a note of it in their pocket notebook and ask you to sign it. If you do sign that notebook, it can then be entered into evidence and used against you. The last time a police officer asked me to sign his pocket notebook, in that instance to acknowledge being reported for a made-up offence the police later accidentally recorded themselves admitting was generated for the purpose of getting a CBO against me, it went like this.
I would just ask you if you can sign my pocket notebook to acknowledge that.
You can stick your pocket note up your arse sideways. Do one.
Well, that's not very nice.
So that's everything I can think of covering the arrest process, but if you'd like to learn more about protecting yourself from not just the police but the CPS and other judicial bodies, I highly recommend the book Copper Stopper by Rob Warner. I'll drop a link to the website from which you can buy a copy in the description. I asked you guys if you had any questions relating to police arrest and detention, and there were quite a few, so I'll upload another video answering those, as this one is already quite long. Finally, if you've been mistreated by the police and your rights violated, then please file a complaint and, if possible, a lawsuit. There are law firms specialising in actions against the police that can help you with both if you have a strong and genuine case. The police fail to uphold every principle of policing, they fail to uphold your rights, they fail to uphold the law, and they persecute the public whilst protecting the self-serving interests of the powers that be. And they get away with it time and time again because the people have failed to hold them to account time and time again. I hope you found this useful and informative. If so, please consider making a small donation to my Ko-fi, linked in the description, to help me continue my work. Leave a like and comment, share the video, and subscribe for more similar content.